Next up, the United States Supreme Court, where the conservative majority upheld a Tennessee state law that prohibits certain kinds of gender-affirming care for minors. The justices found the law does not discriminate on the basis of sex, but the High Court's liberal minority dissented. The Tennessee statute known as SB 1 prohibits the use of puberty blockers and hormone therapy to treat transgender teens. 3 young people affected by the law sued the state, alleging the prohibition violates their constitutional rights to equal protection. The court's conservatives twisted themselves into a pretzel to argue that the law doesn't discriminate on the basis of sex, that it instead restricts on the basis of age and how the medicine is used, as in the restriction only applies to minors and to gender dysphoria treatments. Therefore, the majority claimed, the law doesn't need to be subjected to more legal scrutiny to determine if it's discriminatory. This reasoning is absurd, according to the dissenting opinion written by Justice Sonia Sotomayor. SB 1 plainly classifies on the basis of sex, she wrote, noting that the law does still allow hormone therapy for adolescents until gender is taken into account. Sotomayor made her point in this hypothetical, quote, "Consider the mother who contacts a Tennessee doctor concerned that her adolescent child has begun growing unwanted facial hair. This hair growth, the mother reports, has spurred significant stress because it makes her child look unduly masculine. The doctor's next steps depend on the adolescent's sex. If the patient was identified as female at birth, SB 1 allows the physician to alleviate her distress with testosterone suppressants. What if the adolescent was identified male at birth, however? SB 1 precludes the patient from receiving the same medicine." Sotomayor then lashed out at her conservative colleagues, accusing them of doing, quote, "irrevocable damage to the Equal Protection Clause," that, quote, "invites legislatures to engage in discrimination by hiding blatant sex classification in plain sight. It also authorizes, without second thought, untold harm to transgender children and the parents and family who love them. There is no constitutional justification for that result." 27 states have already passed similar bills to SB 1, restricting gender-affirming care for trans youth. So, what started as a years-long cynical campaign to distract and divide the working class by scapegoating trans people has become an actual crusade to eliminate trans people from society. And now, the Supreme Court just gave its blessing to it. Hey, thanks for watching. Hit the subscribe button so you don't miss any of our new videos. Also, if you want to see Means Morning News in its complete form, not just the clips we post here, head on over to Means TV and get access to all our new episodes and our entire backlog, plus tons of other great movies and original TV shows.